I'm Drew Breezy, and this is the Comm Center. We're going to use our expertise and experience to delve deeper into the Hannah Payne incident, part of a multi-part series of a compelling true crime flavored case out of Clayton County, Georgia. We're going to talk about the 911 calls and the communication supervisor's role in the courtroom. We'll talk about courtroom testimony and demeanor. And is there a little more to this charge and trial than meets the eye? Have the criminal justice system waters been tainted with the political poison like it's Flint, Michigan in 2015? On the Comm Center.
I'm John. I'm an active 911 dispatcher in the field. I've been doing that work for about 9 years. So I'm not exactly an expert, but I'm pretty well practiced. But joining me, as always, is the expert here. He was a cop for 30 years. Drew Breezy. He's a police officer. He was a lieutenant, a detective, dispatcher, dispatch supervisor back in his prime. He's our podcasting partner with Police Benefits. So what happened with Hannah Payne? In 2019, Hannah Payne was in a collision in Georgia. A vehicle collision occurred in which she was passing through an intersection, and a red Dodge Dakota passed through a stoplight and struck them. All vehicles were stopped at the scene for about 20 minutes. The operator of the Dakota was in a fugue state. He was confused, possibly intoxicated, possibly having diabetic shock, possibly whatever. Multiple people observed this. Multiple people dialed 911. In our first part of this series, we covered those 911 calls. And what happened eventually is that the operator of the Dakota left the scene. Hannah Payne had dialed 911, and then she dialed 911 again. She was told not to follow, not to chase, not to pursue, not to do any of these things. But she says, I just want to get the tag number, which for investigative purposes is all we would really need to discover the identity or the owner of that vehicle. The Dakota, was also disabled with heavy front end damage. The radiator was leaking and steaming, and so the vehicle's not going to get very far. Suffice it to say, there was no reason for Hannah Payne to go after this vehicle. However, when challenged about her actions, she became incensed and said, well, this person is drunk, and I'm going to tell you right now, I'm not going to follow them. So even when she was given prudent instructions to discontinue, she did, sort of on the principle of the matter. When she met up with the person, she engaged in some kind of maneuver that involved stopping the vehicle, and at gunpoint, she insisted he get out of the car. A scuffle of some sort ensued. We covered both of these in the first two parts. We talked about a lot to do with the personal exchange between Hannah and the driver of the vehicle on the side of the road during the interrogation, which was in part two. But now Hannah Payne has felt trust in the police to tell her side of it without a lawyer, and it has gone very badly for her in the form of facing charges. So, Drew, what can we expect from part three?
Look, I think it's an important case for a lot of reasons, because it can help us tell the dispatcher story. One, two, it can help us tell the story of a court case, the court process. And like I said, it's kind of true crime flavored. I think, we have a little sprinkling or a dash of true crime in our DNA. So, I love to tell a good story, and just hearing you recount how the story went down and then matching it to like all of the stuff in the weeds, I think that we tend to get lost sometimes in social media by the headlines, and it's or just the abbreviated version of it. And I'm not saying you got anything wrong, but I'm going to offer everything to you like in depth, which is something that I've been prone to doing for a while anyway. But I want you to take a look at the flavor of that county. It's called Clayton County. This is Tasha Mosley. Tasha Mosley is the prosecutor for the district attorney for Clayton County, Georgia. Clayton County, if you don't know, is, let me see if I have this somewhere.
Are you looking for demographics?
Yeah, I was kind of looking for the map, but at any rate, if you just look, I think just southwest of Atlanta. I mean, it's literally a stone's throw from Atlanta. So let's go back in time a little bit. Let's jump in our hot tub time machine and take a moment to realize that in 2020, we had a lot of stuff going on in that area. Now, there's the Garrett Rolfe situation, which was the Rayshard Brooks case, which is ironically a drunk driver who fell asleep. Where, John?
At a Wendy's. He was trying to get inside to get to the super bar.
I'm sure. Well, he left the super bar and fell asleep in the drive-through of the Wendy's. And there was a struggle between Garrett Rolfe and Rayshard Brooks, and Garrett Rolfe's partner, who I just don't remember his name off the top of my head, but they were Atlanta area officers. The struggle ensued. Next thing you know, Rayshard Brooks, just like the whole confrontation, we'll call it, the whole investigation was very cooperative on Rayshard Brooks's part. The officers were very polite. I mean, it was just like a typical DUI investigation, so to speak. Then when they went to put handcuffs on him, the fight began between the two officers and Rayshard Brooks on the opposing end. And at some point, the Rayshard Brooks got a hold of one of the officer's tasers and was running away and began firing the taser, and they shot and killed him. And so the outgoing DA at the time in Atlanta decided that he was going to criminally indict these two officers for doing their job, essentially. So you've got that going on. Then just to the, I guess it would be southeast. I'm horrible with directions. Away from the sun and down towards 4:00. There was another very famous case in that era, like 2021, 2020, somewhere around in there. It's a fellow by the name of Ahmaud Arbery, right? So Ahmaud Arbery was, those guys were convicted, but this all happened in the same time frame. I wish you would be more professional, John. I really wish you would keep it together. It'd be more
I'm locked in.
I am not. So I'm locked out. So just think of the tone and tenor of everything that's going on. You got Derek Chauvin floating around the air. John and I were talking about this before we even came on today, that this incident took place in 2019, but the conviction of Hannah Payne was in December of 2023.
No, I think you're right. When you were talking about, and I don't want to give away the prize here, which is the foundation of the show, but I think if there's so many cases where if they had happened in a different era, I think the turnout would have been radically different. But what happens is we're already in a pretty charged up era in 2019, just because a lot of what's going on with the media and politics is they're trying to stir the pot when it comes to racism because they don't like who the chief executive is in 2019, and they're trying to activate their base about the inherent violence in the system, Drew. But then we also had that horrible incident in 2020 with George Floyd, and it affected so many cases that happened right before and right after, because whether we like it or not, the George Floyd case probably came to bear in some of the minds of the jury, right? Like they're incensed about, gun violence on Black people. And you can instruct a jury that, they're not to consider anything else but the facts. And you can instruct a jury that they're only supposed to consider these certain sets of facts, so that they have to convict or acquit based on the letter of the law. But I think we all know that human beings don't exactly operate that way. They're not machines. And so given a chance and properly primed, I think it's entirely possible that emotions and the heat of 2020 and the fallout from that was used to make her a Derek Chauvin person. And you could say that Derek Chauvin deserved conviction, and so did Hannah Payne. But both of them are serving life in prison for this. And I have to wonder, would those sentences have been that had they been in another era?
I was trying to find the... I'm pretty sure it was his name was Paul Howard. Maybe I'm trying to figure out who that caused. By the way, that caused a police chief to resign, a major metropolitan police chief to resign.
It caused a lot to happen. I remember I was actually when everything that was going on with that, there were some dispatcher pages who were talking about how police officers were not responding to any incident in Atlanta because of the fallout from that. And I went to an app called Broadcastify, and I wanted to hear communications in Atlanta. Now, if you think about a city like Atlanta, they're not going to be less busy than my communications. So I know the sort of the beat and the frequency at which people are communicating on the radio in my jurisdiction, and it's fairly frequent on a busy night. And I turn on Atlanta comms, and I don't hear anything but a buzz and an occasional beep, because all officers are not responding to calls, and so there's just hundreds and hundreds of calls for service just waiting in Atlanta that night. It was very eerie.
So Paul Howard was the district attorney that brought these charges. I believe his name is Paul Howard, and he was outgoing. He was getting ready to, he had been defeated, I think, in the primary by someone by the name of Fani Willis. And so she was getting ready to take over. By the way, she declined to prosecute that case. So she took over that district attorney's office. She didn't want the case. Then I think the attorney general appointed a new prosecutor, and they eventually dropped all the charges against these two officers. It should be noted that Paul Howard, not more than 2 or 3 weeks prior, or maybe 2 or 3 months prior, had tried to indict a police officer for firing his taser at a subject who later died, and said that was deadly force. Then when it came to Rayshard Brooks firing that another officer's taser at the two police officers, he said that was not deadly force. For some reason, it just changes. And it always, and these are the poisons of the criminal justice waters that I keep talking about, because for some reason we are looking at the color of the skin of the defendant and the color of the skin of the police officers all the way around, or vice versa. And in this case, in the Hannah Payne case, we're looking at the color of the skin of the poor man that was killed in this. Okay, he was more than likely having a medical episode. I don't think he was intoxicated, but he sure acted like he was. And the color of the skin of the defendant is white. Therefore, this has to be racially motivated. But that math never works.
It doesn't. And I don't think there's any proof. And not only that, but let's suppose that there was. Let's suppose Hannah Payne is an avowed racist. She's got all the marks of that. Her social media, very ugly place to be. So what? It's not a crime to be a racist. It's not in Georgia statute, so far as I know, to be a racist. That would be, if you criminalize that would be a thought crime. Right. And if you wanted to do some sort of enhancement for that and call it a federal hate crime or something, unfortunately, those statutes exist. But what does it matter what was in her heart? What matters is that she pointed a gun at someone and the gun discharged. Where does skin come into it? A human being was shot by a human being.
Yes. That's kind of my point. So let's get a snapshot of what this district attorney is. And I'm not accusing this district attorney of anything. I think that she has a tough job to do as it is. I think any district attorney does. And whether I don't care if George Soros himself handed the campaign check to these people, they still have a tough job to do, because they still have to make decisions based on, families' lives. And, I think that sometimes they get caught up they think that they need to set the tone of governance versus represent the people that elected them or put them there. So I'm not saying that this is what happened here. I will tell you this, that this particular DA, her name is Tasha Mosley, she is definitely I don't want to say anti-gun. She has a focus on gun safety, which could be interpreted as a method of gun control. And who's going to argue against gun safety, John? But let's take a listen to one of her PSAs here.
This year alone, the district attorney's office has seen a rise in violent cases involving guns as well as accidental incidents. My office is prosecuting more than a dozen cases involving guns where these situations could have been avoided. Citizens of Clayton County, we need to put the guns down. Not only are our older citizens losing their lives to gun violence, but our babies are dying too.
Okay, so this is where I say that she has a hard job. Who's going to argue with that? Who's going to argue with put your guns down or be safe and don't kill older people, and let's not kill younger people?
But the logical argument of it is a fallacy, because she's saying, oh, she appeals to the babies and the old people. She's not mentioning that by and large the amount of gun violence that's happening is gang violence there, and it's happening between Black people. I don't know if she made race an issue on that or not, but she's talking so broadly about it, and she's mentioning the babies and the old people, but it's not a realistic reflection of what gun violence is in her community.
Right. And the gun violence stat sometimes is a little bit skewed, because a lot of the gun violence deaths within the statistics are actually suicides. It's actually people killing them, using their own hand. All right. So you got that. You got a recipe here. You got the sprinkling of kind of anti-gunish, which was, I think that was a 2023 PSA she did there. So here's this also. This is from the U.S. Attorney's Office. So the minute she took office, she's got a job to fight corruption. And Victor Hill was the sheriff of the county, Clayton County, and he was indicted for civil rights violations. And as a matter of fact, he was indicted federally, not by her, but she had obviously had to. It's the same county, so obviously that there's going to be some kind of cooperation, if you will. So Victor Hill, the sheriff of the county, has been indicted by the federal authorities for civil rights violations and was sentenced to prison for civil rights violations. So he went from sheriff of a county handling stuff within a jail to being in prison himself. So you've got that in the mix.
It just doesn't pay to be a cop, Drew. I've been saying this for years now.
Yeah. I think that he did a few egregious things, like on camera. He just basically was a no nonsense, like not in my county kind of guy. But there are constitutional limits of what you can do in your county.
The Eighth Amendment still applies there, but it just at the risk of like speaking out of turn, because I don't really know the guy. But I mean, they went after Joe Arpaio too. I mean,
yes, several times, and he was never successfully prosecuted, by the way. But so then there was this Eric Holmes case. And Eric Holmes was a young man who was, just a very obviously very innocent young man who had never been in trouble before, other than driving the stolen car with 2 guns in it. And he had never been charged, I don't think, with anything, as his mother would bemoan. And yeah, I get that a 14 or 16-year-old kid is dead. However, he took his hand off of the wheel to reach for a multicolored gun that was that had been reported to the officer as being in the vehicle. So the officer shot him. He ended up killing him. Tasha Mosley took that to the grand jury, and the grand jury said, you ain't got it. He was doing his job, which is the purpose of the grand jury. So she had to very boldly get on camera and say, okay, people of the community, this is what happened. These are the facts of the case. I brought it to the grand jury. The grand jury did not feel that there was sufficient probable cause to charge this officer.
Yeah, but even taking it to them, though, she gets to grandstand, yes, and she gets to say, I'm going to make something political out of this. I'm going to show my constituents that this is the kind of stuff that I'm going after, and I'm going to put police officers on notice. And if the grand jury were not a requirement for an indictment, she probably would have gone ahead and prosecuted. The grand jury in this case to act as a circuit breaker against an egregious act of injustice. They're the ones who were able to put a stop to it. But Drew, a good prosecutor is going to know what he or she can get an indictment on, and uses their discretion to not waste a grand jury's time in the first place.
Well, that's true. But I think you're kind of on the right track. She's like, let's just put it in front of the grand jury and let them decide. That way it takes the heat off of her, but she can still hold the police accountable. Now, the thing that you have to think about is, well, how do you know the police aren't holding themselves accountable? Well, the sheriff was indicted. Well, was the sheriff indicted because he was doing things in the jail and that's, in the water, or are they actually corrupt? I mean, there's a lot of layers to this, but she used the system. And not only that, John, when it came back as no true bill, they're not going to indict this guy. Her quote after the press conference or whatever was, we looked further into it and we have decided to not put it in front of another grand jury. Like, oh, thank you. Like, you're going to let this grand jury decide until, or are you just going to keep going? See, these are the things. Like, this is the mind F that somebody in law enforcement, some of the guys, the government, that we have to deal with, because yes, we are on the side of the prosecutor because the prosecutor represents the people. They put together the case beyond proof beyond a reasonable doubt to a jury of your peers. But we, as police officers, 911 operators, first responders, put this case together. We bring it forward on behalf of the people because there's probable cause, warrant a man of reasonable caution that the person more likely than not committed the crime. So, we're all working in concert, but we're more on the side of the prosecutor than we are of the defense. However, if you take a look at the totality of the criminal justice system, you better be on both sides. You better be impartial in this. You have to call balls and strikes, because this is what will happen. She will just endlessly keep going. She'll just keep going. She has an endless budget to retry and retry and retry and retry until she gets conviction. There's no defendant on the planet that has the endless budget to say, okay, we're going to keep defending and defending and defending until we get a no longer a hung jury. And it's, you know what I'm saying? So
yeah, she could keep going after those indictments to make herself look good. The thing that irritates me is that the common public doesn't even understand the difference between a grand jury and a regular trial jury. And they don't understand the difference between a charge, a conviction, and indictment. All they know is that it's a soundbite on the news, makes it sound like she's doing something. And yeah, without jeopardy attaching, she can endlessly assail these people. And the whole point of the system is that when a grand jury says, no, there's not enough evidence here to get an indictment, the district attorney is supposed to pack their bags lacking some newly discovered compelling evidence. The fact that they could just continue to harass them using the legal system is insane to me. Yeah.
Right.
I guess what the defense attorney can do is they can ask for the case to be dismissed with prejudice, meaning you hope that that the case can't be brought against them again. I mean, there are legal remedies for that, but again, if they come up with some new compelling evidence or something, or if they wanted to release this slowly to make as much book out of it as possible, I don't put that past politicians to do that.
No, I don't. And that's why I'm saying the politics needs to stay out of this, whether it's indicting Donald Trump or indicting Hunter Biden. It doesn't belong in there. Like, if they committed a crime, then fine, but let's not dig until we find something just so we can tit for tat. Check this out, though. Bloomington activists and 60 others indicted in connection to Cop City protests. Now, do you remember this? This was Antifa at Cop City. Okay. The Antifa, they were building this huge training complex, which, never ceases to amaze me that you need more training, but then they build this huge training program, a training facility out in the woods in Georgia. And the Antifa comes through and ruins it, smearing pig's blood all over it because,
and the people don't stand up against that, the police have to defend themselves saying, that we need this facility or whatever, but where are the people at? The people are like, the people, meaning you and me and everyone that votes for anyone, should say, like, this is our facility where we train our police officers, and we don't appreciate a radical margin Antifa or whoever. Yeah. We don't appreciate them assailing it. It should be everyone who's upset about that, not just the police or pro-police people or pro-police politicians. Everyone should be mad about that.
So essentially, the people at this music festival that were what they called it was under the guise of a music festival. I've never been to a music festival with Molotov cocktails, but so it was under this guise, and they were all arrested for, what all of a sudden all these prosecutors started calling a protest, which is not necessarily true. This, once you introduce Molotov cocktails, it's no longer a protest. But here's the thing. They were given conditional bond. It was they were charged with domestic terrorism. They were denied bail. Sounds familiar, January 6th. But it says, in response to those charges, more than 60 organizations, including Human Rights Watch, Civil Liberties Defense Center, sent a letter to Attorney General Chris Carr, DeKalb County District Attorney Sherry Boston, Fulton County District Attorney Fonnie Willis, and Prosecuting Attorneys Council Chair Tasha Mosley, urging them to drop domestic terrorism charges brought against the protesters. The letter stated that the charges stigmatize the anti-protest measures and will dissuade future activists from engaging in confrontational protest tactics. She agreed with that. She was thinking that they should probably drop the domestic terrorism part and maybe look into something else. So I'm just saying, I'm not saying that she's anti-cop. I'm not saying that she's corrupt by any stretch of the imagination. She obviously has let the people speak on both sides. There are very fine people on both sides of this, John. So she is, but I am saying that it was in the water, and Tasha Mosley, if she is the head of the office, just the same as if you're saying the sheriff is the head of the office and he's corrupt, then we need to look deeper into what's going on here. Well, if she's the head of the office and she's presenting these, types of prosecutions or reasons for prosecuting, then maybe that's what her ADAs are doing as well. So one final thing to look at: family shocked at grand jury decision to not indict officers in inmates' death. This is the same Clayton County, Georgia grand jury. They decided not to indict 6 Clayton County jail deputies charged with involuntary manslaughter in the in-custody death of an inmate. I don't know if you'll remember this case or not, but essentially what happened in this case is that he was, it should be on your screen here, maybe not. He's, they're fighting with him. You can see in the upper corner there, he's trying to jump, obviously trying to jump, for whatever reason. I think they ended up tasing him, and there were 6 deputies involved, and he died. And their response to that was, okay, well then let's indict them all for some type of manslaughter. And the grand jury came back and said, how about no?
No, I mean, the taser is a potentially lethal weapon as long as the use of the taser was justified. I mean, yeah, the death is a foreseeable outcome of the use of the taser, but we understand that, and it's less lethal than a firearm or whatever. But why did they get all 6? First of all, like it was some sort of conspiracy or felony murder type situation, right, rather than just one guy who pulled the trigger. I don't get why it would be all 6 in the first place.
So how do we combat this, John? Here's how we combat this as public servants, as 911 operators, dispatchers, supervisors, law enforcement officers, first responders, firefighter, paramedics. We just get out there and do our job and tell the truth. And the thing is, you have to understand that we don't have, you can only control so much. You have control over your universe, and you should, live that way. And all you can do is what you can do. You can't control look, I say this all the time. I used to say this all the time when I was teaching in the academy. This is cops and robbers. It's just that the stakes are higher. The stakes are life and death. And you're taking somebody's freedom also. And that's very high stakes. So the best thing you can do is just go in there and tell the truth. If you made a mistake, go in there and tell the truth about it. If you don't circumvent the mistake by covering with this little blue lie and like, oh yeah, I forgot the fingerprint or whatever, because that's dishonest. We don't want that. A good prosecutor can overcome any mistake you made. Just get in there and tell the truth. I believe that Hannah Payne told the truth. I think that you'll see in her testimony next week that I may hold a little bit of a different opinion on it. She obviously still needs to be held accountable. But all we can do is be held to the standard of truth. So I want to go over what the 911 dispatch supervisor, Miss Superer, testified to. We're going to go over her complete testimony, and I've got some tips built into it. How's that? So Kristi Superer is the 911 dispatch supervisor in Clayton County in this instance. So let's watch her testimony. What they're going to do is they're going to go back to okay, hold on a second. Back up real quick. There's something called the rule of sequestration. And if they invoke the rule, it just essentially means that no witnesses that are going to testify in this case can sit in the courtroom while the other witnesses are testifying. Therefore, your testimony is pure. You're not tainted by anybody else's testimony. So what they'll do is they'll send a bailiff out to the lobby to go get you. And you should walk in very confidently, like Kristi did here. Walk in very confidently. There should be no reason, like everybody's going to have nerves. I think when you don't have nerves, it's probably time to move on to a different career. But just walk in very confidently. There's nothing wrong. Just kind of generally nod to the jury, be pleasant, be nice, just like the judge is.
Just go in there and act like God sent you to punish the people of
right. Right. Make sure that you unbutton your shirt far enough so they can see the Punisher's skull on your chest, and then just respectfully acknowledge the defendant if the opportunity presents itself. You don't want to show any impartiality. You don't want to show that you're in favor of the defendant or anything, but you're there to tell the truth, to call the balls and strikes, and you have no clue what was said before you or what's going to be said after you. So your best bet is just to get in there and tell the absolute truth, because when you sit there and wait for the jack in the box, when you sit there and wait for what's going to trip you up, there's going to be a problem. So they're going to swear you in.
Or affirm the testimony you will give before the court in this matter will be the truth, the whole truth, and nothing but the truth, so help you God. You can take your hand down. Oh, I'm sorry, sit down too. Yes, you may.
Okay, that's a very humble moment, but it's very good. This is almost like a game of Simon Says. She raised her right hand, she swore in, she swore or affirmed, and she's like, okay, you can put your hand down now. And she put her hand down. And she's just standing there and finally the prosecutor says, oh, you can have a seat as well. So it's almost like Simon Says, sit down. It does show a level of obedience, and it gives reverence and respect to the court process. You never know when you should be sitting. You never know when you should be standing. If the jury's getting ready to leave, obviously everybody in the courtroom is going to stand up, these kinds of things.
Yeah.
Okay.
You'll just make sure you're speaking into the microphone so everyone can hear you. If you would please state and spell your name.
Kristi Superer, Kristy. Last name is Supperer.
So when I keep calling you Miss Sufferer, I'm saying it wrong.
Either way is fine.
But it's Superer. Okay.
That jogged something in me as well. There are times when somebody, like a defense attorney, is going to intentionally call you by the wrong name to get your goat, but you've got to just maybe correct once and move on. You can't it's deputy. If they keep calling me Officer Baxter, I'm not gonna argue that.
No, you can't play little games like that, which I don't think any games are in play here. I've seen such games happen before, but I was in jury selection last year, and when nobody knows each other really, and we're all just kind of going off of documents, and now we're seeing people for the first time and addressing them. And her name is a little complicated, I could see why they try to make that all right. But generally what you see in the court is people trying to show that general level of respect. I am saying your name correctly, right? Like judges and clerks, they'll all ask for that.
All right. So, there'll be a point later that I go into it a little further, but your reaction is everything to that jury. So if they're able to get your goat, you're going to affect how the jury views your testimony. So just be careful of that.
I haven't said it right once. So, how are you employed?
I work at Clayton County E-1.
And what is your job description?
I am the training and professional standards supervisor.
So just answer the question, nothing more, nothing less.
How long have you worked in 911?
Yeah, a total of 20 years. I've been with Clayton County for over 7.
Just FYI, also, this is the prosecution asking the witness questions. This is the prosecution's witness. There was definitely a pre-trial meeting before this between these two.
Definitely.
They discussed everything that that was going to be asked. They probably were given tips of how to answer, not necessarily what to answer, but how to answer. I don't want you to worry about this. This is why I'm asking this.
Are you familiar with how 911 calls come in to the call center and how they are kept and maintained?
Yes, ma'am.
Tell the jury a little bit about that, please.
So our calls have to be kept on file according to state records for a number of years, and then they have to be made available if someone requests them through open records. And only certain people can access the records.
And when a call comes in, how is the call recorded, and how does that start?
As soon as we pick up the phone, the call starts to record.
And the recordings that you obtain from someone who calls 911, are those recordings kept in the ordinary course of running the 911 center?
Yes.
And is there any ability, either during the call or after the call, to alter or change what is recorded in any way?
No.
In this particular case, on May the 7th of 2019, did the 911 call center receive 2 911 calls from a person by the name of Hannah Payne?
Yes.
And were those calls recorded?
Yes.
And were they maintained in the ordinary course of business?
Yes.
Are 911 operators given any training as to how to address or talk to various calls that come in?
Yes, we do have training. They train before they go out to the floor to take calls. They train in the classroom. We have different protocols that we use for different situations.
And so if a 911 operator is giving instructions, would that generally be part of what they were trained to do?
Yes.
Yes or no questions require yes or no answers.
Yes.
I'm going to approach what has been pre-marked as state's exhibit number 4.
So what she's doing is she's walking up to her. She's going to ask her to identify a piece of evidence so they can get that into the record.
Do you recognize state's exhibit number 4?
Yes.
And did you initial the envelope that contains the disc indicating that you had the opportunity to listen to state's exhibit number 4?
Yes, ma'am.
And the disc that is labeled as state's exhibit number 4, does it contain the full content of 2 911 calls placed by defendant Hannah Payne in this case?
Yes.
Your Honor, this time the state tenders state's exhibit number 4.
Yeah, presuming that once it starts, it does have knowledge of 911 calls. You better stop.
So the defense, before the judge makes a ruling on whether that's going to be admitted into evidence, the judge has to ask the defense if there are any objections, and he's like, "No, we pretty much have reviewed this." So you'll know, John. Also, this is considered a business record. So a 911 call would be similar to a police report in the sense that it's self-authenticating, meaning it's a piece of evidence where hearsay is allowed, because it's not actually the person that took the call that's testifying. It's somebody that is in charge of the system that records the people that take the calls. It's considered a self-authenticating document. Therefore, in the sense, like, that type of hearsay is allowed in the trial.
Permission to publish? Yes.
So they're going to attempt to play this call in the courtroom. There are times when the AV systems in the courtroom don't work, and you just have to go with the flow. You sit there very patiently on the witness stand. Don't change your affect. Don't react. Don't laugh. Don't giggle. Don't do whatever. Just take it in stride.
Enough to allow us to work through the technical difficulties. We're up and running, and Chief Assistant, you may continue.
At this time, the state would publish the first 911 call of the defendant, which is state's exhibit 4A.
Okay.
I edited some of that out. We've heard the calls.
Thank you.
So that was the first 911 call.
And based on your review of state's exhibit number 4, were you aware that the defendant then made another phone call from that same phone number to 911 a bit later?
Yes.
Okay. We could publish state's 4.
I actually called 20 minutes ago for an accident, and no one has showed up yet. But I never knew that the guy that caused the accident, who ran the red light, is drunk. And he got back in his car and he looked at my trying to drive away. And can you get his tag number? Ma'am! Yes. Ma'am! He just pulled the cigarette light on his right hand. Right? Ma'am! Please are not supposed to follow him. He hit my car! Okay, you got the tag number. Tell him to come up here now. He's supposed to sit on my God. After the attack. Tell the police officer to turn around. Don't do any violence. And come up here immediately. No, I don't. Okay, ma'am. There's a police officer here now. Okay. Speak with them. All right.
And so, Ms. Superer, when you hear what we could hear from the call when the operator is giving instructions of go back to the scene, do not follow, do not chase, things along those lines, would that be consistent with what the 911 operators would be trained to do?
So this was likely discussed in the pretrial meeting, but when she says very casually, like giving instructions like do not follow, do not chase, go back to the scene, those could very easily be missed. This is why hindsight is always 20/20. When you play that in the courtroom and it sounds loud, or when you read it in a transcript and it's right in front of you, it's very apparent. When you're listening to it on the phone or you're living in the moment, it may not be as apparent. That's kind of where I was going with Hannah's testimony earlier.
She is the individual that answered the phone, correct?
No.
Any kind of comments that she makes about the said or hearsay.
Okay. A response, attorney.
Judge, it's not hearsay. The recording is already in evidence. We also filed a notice of business record, which
All right. The reason I left this in is because you need to stay silent during any objections until the judge makes a ruling. Often what happens is you're asked a question from either the prosecutor or the defense attorney. You take your breath, you're getting ready to answer. Do not say anything further if somebody objects, because that means that there's an issue with the question. The judge has to decide, am I going to allow this? Am I not going to allow this? You're not going to help yourself by blurting out an answer. You could be bounding on the edges of a mistrial if you say the wrong thing. So just let them object, let them fight it out, then answer the question. Sometimes you might need to have them ask it again so you can remember what was asked.
you testified to a business record, which is the exception to hearsay, and we put this defendant on notice that we were going to tender these 911 calls under the hearsay exception of business records.
She goes out the line.
So all he's making the argument that, look, I get that this is a business record, but if you're asking this witness questions about what that operator did, that's not the same thing. That is more hearsay.
Go exactly what the intent was. She talked about what's on it, but if there's an intent of what was being these comments, what was said, I would object.
Okay, so I'm going to overrule the objection because she was qualified as a trainer and as a supervisor, and the testimony that she's given is consistent with what the training would be. So I will overrule the objection.
Thank you, Judge. And again, not asking why you think a particular person said something, but are those types of instructions, go back to the scene, don't chase, don't follow, things along those lines, are they consistent with the training that is provided to the 911 call takers?
Yes.
Thank you. And Judge, we have no further questions of this witness at this time.
Say your last name again, so I don't miss it.
Super.
All right, so this is largely important. This is where a lot of young officers make the mistake, and this is where I can see people who don't testify on a regular basis make this mistake. The defense attorney, go for it.
Just circling back to that objection, I wanted to mention the reason also for the objection. Sometimes if there's any reason at all to object, a defense attorney absolutely should object. If it's, as long as it's not completely groundless, as long as the judge has something to consider, and you heard her discuss it. Well, we have certified her as an expert 911 dispatcher, and she is able to talk about the training that these dispatchers have. But the defense attorney should still absolutely raise this point of an objection, even if it's obvious, because raising objections, if you lose the case, any of these may be entry points for you to have grounds for an appeal. So any good defense attorney is going to be looking at every situation, every witness, the basis of the introduction of evidence. Is it just, should the jury see this or not? And they should object to it whenever they can, whenever there's a basis for that, so that in case they lose, they've got something later. Go ahead, Drew.
That's an excellent point. And so you'll understand, the general public may not know this. The appeal is all done with the record. It's not necessarily done with people testifying again to what happened. The basis of the appeal could be that she should not have overruled this objection. Well, all they're going to do is take the transcripts of what's being said in the courtroom. They're not going to take new testimony or arguments from either side. They're just going to review what was said on the record. So the judge erred because she should have done X, Y, and Z, but the judge gave a clear explanation here. Excellent point, John.
Super. Okay. And you stay.
Oh, I missed this point. Don't ever, this is the trap. Don't change your demeanor. So if you sit there, this is why I say, like, we're calling balls and strikes here. So just give the truth. Even if you know that it's like, oh shit, this is bad, just answer with the truth, because you never know where the trap is leading you, and you can't guess. You definitely can't guess. And you're going to have some very friendly interactions with defense attorneys. You're going to leave the courtroom, and then you're going to find out later that that defense attorney called you a liar, tore you up one side and down the other, and showed that you were lying when in actuality you probably weren't lying. You just misspoke or something. So it's very important not to change your demeanor, John. Anything else?
No, I completely agree. Just remember, there's civility there, but it is an adversarial system. And if you speak too widely or you don't constrain your responses, it gives them more leverage. It gives them more doors and windows to enter into to either impeach your credibility or bring in another piece of evidence that was previously excluded. You never know. So
or show the jury what a jerk you are.
That there was training that was given to talk about not to chase or to stay back. When was this training given?
That is our training that we go by whenever we hire new employees. They go through an academy in a classroom, and it's usually 3 to 4 weeks before they start taking live phone calls.
And the employee that took this call, how long have they been working there?
I'm not sure.
Not sure. Okay. But you're sure they took the training, correct?
Yes.
Okay. And based on your hearing this call, have you ever sat as a 911 operator?
Yes.
Okay. And as hearing this call, it sounded kind of calm compared to a lot of 911 calls, correct?
I wouldn't say that.
Let's say that you didn't. So you're saying that 911 calls don't have people that are excited yelling, or
they do, but you just never know, when you pick it up, who's going to be excited or who's going to be calm.
Okay. So based on your experience as a 911 operator and hearing this audio, you're saying that didn't sound very calm, the interaction back and forth?
Oh, he's
both the first and the second.
He's trying to trip her up very obviously. He's trying to get her to speak in absolute terms like a Sith. So she's, you're saying this doesn't sound calm to you. Oh, so you're saying that all 911 calls aren't like this. Or you're saying there aren't frantic 911 calls. He is pushing her a little bit here, Drew.
Yeah, I'll tell you this. My secret weapon of sorts, especially, coming from the narcotics world that I was in for a long time, are the defense attorneys, because you can, when you're not in a courtroom, talk sense into a defense attorney who can talk sense into the client. Whereas you can probably, you probably won't be able to talk sense into the defendant, right? So if you're interviewing somebody and they're like, I want to get my attorney and blah, blah, blah. And you're like, perfect. Who's your attorney? Let me call them. I had most of them in my phone. So, we would make the phone calls to the attorney, put them on speakerphone or pass the phone back and forth. And next thing you know, the attorney's talking them into cooperating or doing whatever. That's not to say that and as such, you're drumming up business for that defense attorney, by the way. So obviously they have a friendly relationship with a lot of the cops. It's not to say though, when you get in that courtroom that they don't, they've now hit the Sam and Ralph time clock and they are now the wolf or whatever, the sheepdog, and they are there to beat the shit out of you in the courtroom. They're definitely not your friend in the courtroom, but there's no reason to not maintain a level of respect or decorum.
But
At the beginning of the second.
between the operator and the caller, yes, until the end.
Okay. So, and in the training that they get, if an individual says, hey, I'm hopping to my car to go get a tag, and that's it, they're told to say, our policy, what we learned is not to chase and say it one time and not say anything else.
We tell them that they can do it if they feel safe to do so, but we don't want to do anything to put them in danger nor the public.
So being on the other side of the phone, how would they know? How would an operator know if somebody's going to be safe or not?
If you're following a car going down the road during rush hour, I wouldn't think that would be safe.
It's caution. That's a judgment. I don't know that I would allow that as a prosecutor. I mean,
I would have objected to that question as well, because that and also his question about how many times are they supposed to say that? One time's really enough. Like, should a 911 operator be forced to badger someone and constantly insist that they stop what they're doing? I don't think that's reasonable. But what the defense attorney is trying to say is that, yeah, your dispatcher said not to do this, but they didn't really mean that. They weren't that engaged in telling her to not do it. And he's exploring this gray area between the fact that the dispatcher told them not to do it, the client did it anyway, and then the dispatcher didn't say anything about that, which why would they? They're not in charge of that situation. They don't have any command authority. Yeah, they're trying to say that that the dispatcher wasn't clear, or that Hannah didn't understand that there was danger in the situation, or that what she was doing wasn't dangerous, or whatever. He's just trying to undermine basically everything that a common person listening to this phone call can understand. Go ahead.
Level of their voice or intensity of the voice give an impression as when you were a 911 operator. Would that give you an impression that it might not be safe or it might be safe?
The voice that we use?
Yes.
We are supposed to be calm.
Oh, the voice. I'm sorry. Let me clarify. The voice that you hear coming in on the 911 call. If it's more excited, would you, as a 911 caller, believe that it's maybe not as safe versus a calm conversation?
No, we have people that call about a dog being in their yard that are hysterical. So you really can't gauge how somebody is first.
It's in how he's asking the question, because I think what he's trying to say is, can you make a judgment as a 911 operator whether somebody is listening or hearing what you're saying versus you're just talking to them and they're not? It's being shouted into an abyss. I think that's where he's going.
The question bugs me because it's like you could tell that he doesn't understand the profession at all. Like I completely agree with what she's saying. It's like, no, you really can't tell. You can't tell from how people sound whether or not a situation's emergent or not emergent. You really will get someone who will call in and they'll be hysterical because of a minor problem, and other people will call in, and we've heard it on this show where their affect is completely flat after they've killed their whole family. So you can never judge by that.
Right.
The way they're speaking.
And so you stay calm no matter what. Okay. And in this particular one here, as the conversation pursued, she said, I'm going to go ahead and get the tag. And it was stated that, the policy is not to be safe. We want you safe. You heard that, correct?
Yes.
And then you didn't hear anything else until she gave the tag number, correct?
Correct.
How many times have they trained to say, we don't want you to follow this car, we don't want you to do this? How many times are they supposed to say it in their training?
We tell them that. If they say they're going to continue to do it, then we just try to get as much information as we can.
So you're saying that the policy is to tell them not to follow or not to chase, but to be said, but it's not to reiterate that or come back and say, hey, our policy is this, don't do that.
We would tell them not to do it.
One time, two
And
times,
then-
3 times?
And then we're listening to get other information because a lot of our information comes from hearing what's going on in the background.
So how effective is it to tell them don't chase if you're waiting to get information from them?
It's not our job to
We
affect them.
tell them not to chase.
Right. It's a policy for employees. It's not a policy for citizens. So it's what we're told to tell them. And what they do is their business, and they could end up in a courtroom just like this. Right?
And then that's on them if they do chase. I don't know what the difference is between telling them once or telling them 5 times.
Very good. Well done.
Okay. Help me understand. So it's a policy for y'all to say it, but it's not a policy to try to force them not to or try to convince them not to.
It's our job to take the call and put the information in. And what a person does on their own will is what they do.
So it's a policy to protect 911.
We told her to go back to the scene.
That's okay. So
Asked and not that's not answered. But he has already asked this question though. In fairness, he has tried to get her goat. He's saying, "Oh, this is just to protect you," and she says, "Well, we told him to go back to the scene." She's getting a little hot under the collar here.
yeah, this is a setup of the defense. Like, this is what the defense is supposed to do. They're supposed to build the defense, and they're building a defense. Like, you're saying that there's this policy where you're supposed to tell them not to chase, but you just tell them once and it just goes into the atmosphere. You don't, there's no follow-up involved with that, and she's answering appropriately, but just now he asked a very certain question, but she gave a very, this is like a guy I used to work with used to do that to me all the time. I would ask him, I used to say all the time, "You're doing it again." I would ask him a question about baseball and he would answer with a statement about football stadiums. You know what I mean? Like, you just wait. That's not what I'm asking. That's not even what I'm asking.
That's because he was defensive about it. She's defensive about 911. She doesn't want to get in trouble at work. She doesn't want to somehow make 911 itself liable when, of course, we know that Hannah Payne was making her own decisions. But the attorney, is just trying to rub her the wrong way. And she could say with clear conscience, she says, yes, it's designed to reduce the liability of 911. But at the same time, if a reporting party follows this instruction, it's likely to protect them as well. It protects everybody. Right.
Which is in our policy.
After getting the tag number, correct?
If they can safely get the tag number, we'll take it down
I'm
for the
specifically
officers.
talking about this audio here.
Yes.
It was after you got the the tag number, that you said, okay, now I'd like you to go back to the location, correct? Or the individual on the 911.
I thought she told her before.
She did.
Okay.
Before she got the tag and then after.
Would you like me to refresh your memory?
She did.
Sure.
Play it. Play the whole thing again because the operator did tell her to leave and go back after she got the tag.
Okay. If we could just hold that up. If I may approach it, Your Honor. These are the transcripts.
So you may use anything that might jog your memory, like a police report or some kind of notes that you took. Just understand that they may be admissible, first of all, but second of all, you can't just refer to them without asking the court if you can. So a lot of times what will happen is, like, they will say, they said it several times during this trial, if I show you the transcript, will that refresh your memory? Yes, it will. Your Honor, may I approach? And, they give them the transcript and they say, okay, read page 11. And then they ask questions based on what's written on that page. So you have something in front of you. Just remember, when you're testifying, though, if you have a police report or you have a transcript in your hand and you're a little nervous, you're going to telegraph it with the fact that you're holding a piece of paper in your hand. It's going to be a white piece of paper. and it's going to show. So you gotta kind of keep it low, keep your hands in your lap anyway. John, anything else?
No, I'm not sure what he's driving at, because, I have listened to this call quite a few times and I had to edit it and put it together. The operator tells her to leave the scene, and then she gets the tag number. She doesn't, beat her over the head with that. And then afterwards, when we have the tag number, towards the end of the phone call, the operator wants her to go back, unless I'm gravely mistaken as well.
Okay, so from hearing the audio and looking at the transcripts of the 911 tape, it was said one time, please, ma'am, don't chase, and nothing else was said until the tag was given to him, correct?
Correct, but she did tell her that we don't want her to chase him. She asked her if she could get his tag number, and when she advised that she was chasing him, they said not to do that.
She never advised she was chasing them, correct?
She said she's catching up to him, and that's when they told her that we did not want her to chase him.
This is what I was saying in week one, John. This is semantical. Like, I understand that everyone in the world, but one person understands that don't follow means don't chase. But that one person is on trial right now, and you have to give the leeway to understand that this is how she was interpreting it, and there was a lot of stuff going on at the moment. And I think it's an important part of the process. Like, they never. I think when you hear Hannah's testimony as to why she was saying what she was saying, I think it'll make more sense. But that's not how the jury saw it.
And what was said after that?
That we wanted her to be safe.
And what was said after that?
She said she understood, and we told her that it was not safe for her to chase him.
That's something that's in the transcript. It's hard to hear in the audio. Good job to her for seeing that.
Right. So this is the other part of the gamesmanship too that I want to talk about. You can use the audio when the audio favors you, but you can also use that transcript when the transcript favors you, which you will see in when Hannah is in her cross-examination by the prosecutor. The prosecutor tears her up with a razor blade because of those transcripts. And those transcripts don't translate to what's being said in the, it's a verbatim record of what's said in the 911 call without the benefit of hearing the tone of voice, the pauses, and everything else. So even here, when he says on page 11, does it say that she said to chase him? No. But in reality, when you hear the phone call, you know the tone, you know the tenor, right?
Well, you also know this particular part, which I don't know if the defense attorney is cut off guard here, but where he says, the witness says, we told her it was not safe to chase. He gets up and walks over and looks at the transcript, because I'm not sure if he didn't thoroughly read the transcript or if he was just going by the audio. But as someone who edited the audio for the show, and I can tell you, and I know exactly what you're getting at, Drew, at one point, the dispatcher says it is not safe to chase, but Hannah is not listening at that point. Hannah is about to read off the tag, or she's doing something else, and you can tell that it doesn't register her with all. So that's a difference in the transcript, where you think if you're having a sit-down conversation like you and I are having, if I said to you, Drew, it's not safe to chase, that's going to register with you. If you're driving your car and you're looking for a tag and you're on the phone and you're, regulating speed and making sure you don't hit other people, and also, you're strapped with your 9, you're getting ready to cap an ass or bust a cap on somebody's ass, you might be thinking about something else. You never even hear that.
Yeah. And by the way, the person transcribing that hears both parties.
They do.
And it's never like you're never able to say Hannah parentheses doesn't really hear this. And you know what I mean? And what her response is. Like, right. You don't know what she heard.
That's an inference, right? It's an inference I just made based off of my 20, some years of communicating with other human beings.
Conversation, did you say, do not chase, or did it said one time, and then it was a radio pause or audio pause until she gave the number, correct?
She said, we actually do not want you to chase him. Your defendant said, I understand. And then we said, it is not safe to chase him. So we said,
yes, good job.
Okay. And upon that, what happened? What was said after that?
After that, the defendant advised that she understood 100% and that she was just going to get his tag number.
Yes.
Okay, I get,
what was he thinking? That blew up big time.
I understand the celebration. I'm just telling you, you're gonna appreciate my analogy of he just like the dispatcher said, "Hey, are you an Atlanta Falcons fan?" And Hannah responded with, "I love baseball."
Mm-hmm.
That's where we're going with this. And this is kind of the point of this in general, because words matter. Words, every word matters. Every word in your police report matters. Every word you say over 911 matters, because somebody's life or death hangs in the balance, or somebody's freedom might hang in the balance. So I think we probably should just cut it here.
I love seeing 911 on trial, like seeing how it all works there. That I am just fascinated by the way we've ended the show, though, because he's sitting there just going on like, how many times did you tell her? What's your policy? How many times do you have to tell her? And the dispatcher reads the transcript and says, "We're telling you not to do this." And she goes, "I know." And she goes, "It's not safe for you to do this." She goes, "I understand 100%.
100%.
Which that 100%, man, I get that she threw it away like as a throwaway. Oh yeah, I got you, man. 100%, I got you. But when you read it out in a courtroom, it literally, that percentage becomes a colloquial. It goes from being a colloquialism to being an actual gauge of how well she understands the situation.
I do think, John, when you hear Hannah's testimony, you are going to change your mind about that. Because I'm telling you, I did. I don't think, like I said, I don't think Hannah should have been scot-free. I think that she did introduce a gun into this thing. I don't agree that she ran up on the guy and demanded he get out of his car with her gun out. That's not what happened at all. I think that there was a struggle that took place, and then in an effort to defend herself, she took the gun out. Then he ended up getting shot, and then she was shocked that somebody got shot when she introduced a gun into this thing.
I understand there's the between the chase and the 911 call and the whole engagement is they're actually two separate incidents. And so in some ways, asking the 911 dispatchers about whether to chase or not to chase is all sort of inconsequential. The fact of the matter is she chased, and then we have to talk about self-defense, which is a whole other matter. We talked about how this is really a string of separate events, and we can try to put 911 on trial by saying how many times are you supposed to say this. But my biggest takeaway from this, Drew, is never to use the phrase 100%. If someone asks me something, or if I agree with them, I'm going to drop some random percentage. Oh yeah, man, 81%. I got you. Because if I'm ever called to account for that later, the defense, when they read the transcript of what I say, they say, "Oh, John said that he supported that person 81%. Now I've got enough gray area, I've got enough fog that I can say, well, I don't agree with them, obviously, this percentage of the time, and so I'm off scot-free.
You would just go, "That's the 19%, Your Honor. We're dealing in the 19%.